Hi, Austin divorce lawyer Ben Carrasco. One of my favorite movies from the early 2000s was Wedding Crashers. And if you recall the opening scene, it features Vince Vaughn and Owen Wilson as divorce mediators who are presiding over a mediation involving two warring spouses. They're all in the same conference room, both spouses, the mediators. It's a very acrimonious discussion, and Vince Vaughn and his partner ultimately are able to forge a compromise by finding common ground between the spouses, by having them recall the happier days in their relationship, the wedding and how wonderful it was, how great the food was at the wedding, the qualities they saw in their spouse that they found appealing before they started hating each other. And why am I referring to this? Well, because it dovetails into the topic I want to address today, which is mediation. What is it, how it works, and why it can be advantageous to your case. So mediation is a process whereby divorcing spouses engage a neutral third party, i.e. a mediator, to assist them in finding common ground and negotiating a settlement to their case without going to trial. In contrast to what you saw in the opening scene in Wedding Crashers, mediations are not conducted with all of the parties and their lawyers and the mediator in the same room for obvious reasons. You're going through a contentious, high-conflict divorce. You're not going to have a very productive dialogue, most likely, if you're in the same room with your spouse, and depending on the case, it can frankly be unsafe to do that. So if your mediation is conducted in person, you will be in one conference room with your attorney, your spouse will be in a conference room with his or her attorney, and the mediator will shuttle back and forth as offers and counter-offers are made over the course of the day. If your mediation is conducted over Zoom, and in the wake of the pandemic, many mediations, I would say in fact most mediations today, are conducted remotely over Zoom, but the same principle applies. You will be in one breakout room with your attorney, your spouse will be in a separate room, and the mediator will go back and forth. A couple of things to emphasize about mediation in terms of how it works. Number one, it's confidential, meaning none of the offers that are made in mediation can be used at trial. The mediator cannot be compelled to testify at trial, and nothing that you tell the mediator while the mediator is with you in your room can be shared with the other side without your consent. The other thing to emphasize is that mediation is voluntary in the sense that whether you settle your case at mediation is entirely up to you and your spouse. The mediator cannot force you to sign anything. Your lawyer cannot force you to sign anything. The mediator does not function as a judge. The mediator can cajole and give advice, give you his or her perspective on what the range of probable outcomes will be if your case goes to trial. And of course, your lawyer is there to give you legal advice, and you should only rely on your attorney to give you legal advice in mediation. But ultimately, whether to settle is up to you and your spouse. And if you all can't agree on terms at mediation, then you go to court or perhaps attempt another mediation down the road. I've seen that happen. Or the attorneys can negotiate a settlement agreement outside of court. It's called an informal settlement agreement or an agreement incident to divorce. It doesn't involve a mediator, but it is another avenue for settling your case without going to trial. Why should you do mediation? I think there are a couple of reasons why mediation is a good thing. Number one, it's a lot less expensive than going to trial. Going to trial is stressful. It's unpredictable. We sometimes say that you go to trial, in certain cases you may win when you should lose, and you may lose when you should win. And mediation puts you and your spouse in control of the process. Nobody knows your life and your children as well as you and your spouse. The judge is not invested in your life. The judge does not love your children. Judges are often, they don't make very nuanced or customized rulings. They sort of stick to the basics in the family code. They generally order, for example, a standard possession order, whereas in mediation, you and your spouse can negotiate something that is more tailored and customized to your particular circumstances. So it gives you an element of control that you don't have when you cede that authority to a third party. Number two is the finality of mediation. If you settle your case at mediation, you will sign what's called a mediated settlement agreement, which will contain the terms that you have agreed on with respect to property division, and if there's children involved, the custody terms, and it will say in bold lettering that this agreement is not subject to revocation and is binding on both parties. And what that means is if your spouse wakes up the next day and has buyer's remorse and wants to get out of the agreement, too bad. They can't. They're stuck with it. Mediation, if it results in a mediated settlement agreement, effectively ends the case. The only remaining step is to incorporate the terms of the settlement agreement into a final divorce decree. So if you settle the case at mediation, it's an ironclad agreement that locks you in, which can give you peace of mind and certainty in knowing that those terms that you agree to are going to be honored. Now, the flip side is you may wake up the next day with buyer's remorse, right, and regret what you did and want to blame your lawyer and claim that you were strong-armed or pressured. And that's why it's important to emphasize that this is your mediation. It is your decision whether to sign it. You have the freedom to not sign it and have your day in court. You may regret it. You may go to trial and get a worse outcome than whatever offer was on the table at the end of mediation, but that is your right as the client to do that. And if you find that your attorney is not respecting that right, then you have the right to retain new counsel. So you should not sign a mediated settlement agreement unless you're absolutely certain that it reflects your true agreement and that it's workable in the long run and that it's in the best interest of you and your children. So I hope you found this helpful. If you have any other questions about mediation, please feel free to reach out to me if you want to book a consultation. Thank you.